All right, well, since it is noon, we'll go ahead and get started. I expect we'll have other participants that'll drop in. We've got a handful of us that are here in the Love Inc. office, and I'll just go ahead and make some introductions and then turn it over to our guest, Roger, for the balance of our time here today. So here in the office, I'm Conrad. I'm the side-by-side coaching coordinator, and then let you two introduce yourselves.
I'm Kelly Haithcote. I'm an assistant to lots of people, I think.
And I'm Jane Williams, Program Director here at Love Inc.
And we should have, is Kelly coming in? Do we know Kelly?
She has a Zoom meeting at noon.
She does, so Kelly can't make it. Okay. And then Christina, Eric, you guys want to introduce yourselves too?
Sure, I'm Christina Logsden. I'm a service coordinator here at Love Inc., among other things.
Hi, my name's Eric. I'm a retired old guy that just wants to help.
And then our guest today is Roger Dyer. He'll be speaking on evictions related to housing. Some of you I know are housing coaches. Some of you are working with people from a variety of different backgrounds. Roger, a lot of our coaches, our side-by-side coaches work with people that come from, that are coming for budget-related needs, whether that's housing assistance, for rent assistance, utility assistance. We also do career coaching, and then housing coaching is certainly something that's pretty substantial that we're doing right now, helping people find a place, after an eviction, or as they're even, currently experiencing an eviction. Many of our volunteer coaches focus on career coaching or budget coaching, but they also are drawn into, housing-related needs as well. So it kind of covers a wide spectrum of needs that our people are facing, our clients are facing, our coaches are working with. So Roger, I'll let you go and share a little bit more about yourself, and you go ahead and get started.
All right, well, thank you. And I'm going to go ahead and try to share my screen here because I've got a PowerPoint presentation. Oh, I don't know if I'm able to.
Let me see if I can give you permission then to. Are you able to request to share?
Well, when I click the share screen, oh, maybe this will allow me to.
Yeah, I just gave you permission now, I think.
Okay, can you guys see my presentation?
Yep.
Yes.
Okay, perfect. All right, well, first off, thank you for having me. I'm going to talk today about, I guess, generally tenants' rights, but some specific tenants' rights, specific to evictions and kind of distinguishing between what is an unlawful eviction in Missouri versus what a lawful eviction is. Additionally, I am going to take just a brief moment to discuss the expiration of the CARES Act. The moratorium, the 120-day moratorium did expire. However, there's still a 30-day notice requirement. So I'm going to briefly just discuss that. And then I'm going to get into, again, lawful versus unlawful evictions. There are certain types of things a landlord must do in order for a eviction to be considered lawful. Oftentimes, well, at least on occasion, landlords don't do each of those things, and that can pretty quickly result in an unlawful eviction. I'm going to talk a little bit about what tenants can do in those situations. And then I'm going to spend some time kind of going through the lawful eviction cases and kind of discussing each one and going through the process of tenants so that you can kind of discuss with tenants what that looks like, what they can expect in the event that they're served with an eviction lawsuit. So, like I said, I'm going to start off just briefly discussing the CARES Act. The 120-day federal moratorium on evictions did end in July. The moratorium for the 120-day period prohibited covered landlords from filing eviction cases for non-payment of rent. And while that was great for that time period, rent still accumulated during that moratorium. So what's happening now that the moratorium's expired is that that rent is becoming due. So tenants who were protected by that for 120 days are subject to potential eviction here in the very near future. That being said, there is one protection still left in the CARES Act that will protect tenants covered under the CARES Act for a little bit longer, and that's this 30-day notice requirement. Essentially what this means is that before a landlord can evict a tenant for non-payment of rent during that moratorium period, they need to provide them with a 30-day notice to vacate, and only after that 30 days runs can they then file an eviction lawsuit. So unfortunately, it may result in a lot of eviction cases being filed in the near future, but for now, that is still in place, meaning that at least as of right now, through most of the month, there should not be evictions being filed against tenants whose landlords are covered under the CARES Act. And just to talk a little bit about who the CARES Act applies to, generally speaking, it applies to tenants who are in federally supported housing. Now, that's most commonly, the most common examples are going to be public housing, where the housing authorities, the tenant's landlord, of course, Section 8 voucher holders, and then project-based Section 8, where there's privately owned units, but then they're subsidized through HUD. Those are going to be some of the most common examples, and those are usually the easiest situations to identify because the tenants will usually know whether or not they're receiving a housing subsidy, or even whether or not their landlord is receiving a subsidy to help subsidize their rent. It gets a little more difficult when you start getting into landlords who, maybe the tenant's not receiving a federal subsidy, but the landlord is taking advantage of some sort of federal program, whether it's a federally backed mortgage through Fannie Mae or Freddie Mac, or whether it's a low-income housing tax credit. And there are other things as well. And so those landlords are covered. Identifying those landlords can be difficult. A lot of counties in Missouri are requiring landlords to submit a CARES Act kind of affidavit or verification form when they file a lawsuit. And it's basically just a sworn statement saying that they do not fall within the CARES Act. But not all counties are requiring that. So, in those situations, there are certain things that you can do to help tenants to kind of research those. Certainly, Fannie Mae and Freddie Mac are pretty straightforward. Their websites currently have a database where you can search an address. It'll let you know whether or not that mortgage is federally backed. Low-income housing tax credits, a little more difficult. We were able to get access to a pretty large database from a state agency that lists a large number of properties that receive certain low-income housing tax credits. So we are able to identify, I think more than maybe the average tenant or average advocate's able to identify, but it's still difficult. And so, in those situations, what I kind of advise tenants is that they think that their landlord may be covered, but they're not able to confirm that. And, the landlord's either refused or has indicated, at least to that tenant, that they don't fall under it. Then kind of the last thing a tenant can do is, in the event that it ends up in court, they certainly have the right to ask the landlord on the record whether or not their, mortgage is federally backed, whether or not they, fall under the CARES Act, whether or not they receive any of these low-income housing tax credits and so forth. The scary thing is, I think, is that a lot of these landlords don't actually know that they fall under it. The agency that provided me with the database I've referenced had indicated that, every landlord they've reached out to who they've learned that was violating the CARES Act, it was really an education issue. And once they were educated on their responsibilities to comply with it, then it resulted in whatever case they had filed getting dismissed. But these issues, at least for the next 3 weeks or so, I expect to come up. And so if you have a tenant who perhaps hasn't been able to pay rent during the moratorium, whether they're behind a month or 4 months, and they're unable to pay that, there are a few practical kind of pieces of advice I can give you and to give to those tenants. Unfortunately, at the end of the day, if they've got a landlord who's not willing to work with them and they're unable to pay the rent, the reality is they probably will be evicted at some point down the line. But the sooner they can reach out to their landlord, talk to their landlord about the possibility of working out a payment plan or deferring payments to a future date. And, again, landlord would have to agree to that, but the sooner they can reach out to their landlord to kind of try to work that out, the better. Of course, I always recommend that tenants get those things in writing. If it's not in writing, it simply may not be enforceable in the event that the landlord doesn't follow through on it. And if the tenant does make payments, even if it's a partial payment, whatever, they should get a receipt for that and keep that receipt. And if for some reason the landlord refuses to give them a receipt, I mean, they really need to make sure they get that. But sometimes I'll advise a tenant to follow up with an email or a letter saying, hey, I just wanted to follow up on our conversation and the rent that I paid you and the fact that I now owe you this amount, or something just kind of memorializing that agreement. They can apply for rent and utility assistance as well as other public benefits that might help them get through that period. And then if tenants do receive subsidized housing and haven't already, well, I should say, and have experienced a change in income due to the pandemic, they really need to contact their landlord, housing authority, caseworker as soon as possible to report that change in income, because that'll likely result in their rent being reduced. And I know that at least last I heard, the Columbia Housing Authority, for example, was actually backdating that. So if someone had lost their job, a few months ago and just hadn't reported that, and are able to establish that they did in fact lose the job when they say they did, my understanding is that they will go back and adjust it from that point. So these are some practical things that tenants can do, and if they're in the situation where they're no longer protected by the moratorium and that rents become due and there's threats of eviction, maybe they've already received a notice to vacate letter. These are practical things they can do. Realistically, if they're not able to pay that rent, and that's all the rent that's due either before court or on the date of court, and the landlord's not willing to work with them, it's likely that they will be evicted. And I'll talk a little bit more about what that process looks like when we discuss evictions. All right, so that's all I really had to say about the CARES Act. I don't know, if there are any questions specific to the CARES Act, I could open it up to questions about that right now. Otherwise, I can move on to lawful evictions versus unlawful evictions.
The only question I have is that, was there any protection for people that were with landlords that were not protected under the CARES Act, or was that still just business as usual?
Conrad, I missed the first part of that. I had a little issue with my speaker. Could you repeat that?
So were there any provisions for people that were not with landlords that were protected under the CARES Act, if they were with a private landlord or their own private pay? Did they have any provisions at all under the CARES Act other than the stay in Boone County on evictions?
Yeah, so no, not under the CARES Act. The CARES Act actually only addressed tenants who either received some sort of federal subsidy or whose landlords did. So again, broadly speaking, federally supported housing. It only impacted, the numbers I've heard, is approximately a quarter of landlords are covered or were covered under the CARES Act. As far as private landlords go, it was just the local moratoriums that were in place. And as far as I know, at least the ones that were in my service area, most of them expired around the beginning of June. So since that time, landlords, at least landlords whose rentals are not federally supported, have been able to and have been filing evictions, and the sheriff's departments have been executing those. So that's been going on for some time. Really the only thing I can say about that is because of that period of time that the courts were closed, there was a pretty big backlog. So tenants who normally might have been evicted in 3 to 4 weeks, it was taking quite a bit longer to actually work its way through the courts. But yeah, as far as actual protections, there's really haven't been any in place since that moratorium expired, that local moratorium.
Okay, thanks.
All right, thank you. All right, well, I'm going to go ahead and move on to lawful evictions versus unlawful evictions. And I'm really speaking kind of broadly with respect to unlawful and lawful evictions. There are oftentimes a number of steps that are required. So, a case, for example, could meet some of the requirements or all the requirements that I'm going to discuss for a lawful eviction. Depending on the case, there could be other things that the landlord had to do as well. But what I'm going to discuss first are just kind of really easy ways for somebody to distinguish between what's a lawful eviction and an unlawful eviction. That'll include the most common unlawful evictions. I'm going to go over the statute that actually covers those. And then as far as lawful evictions go, there's a few things, actually 4 things that have to be done in every lawful eviction case. It doesn't matter if it's due to rent, it doesn't matter if the lease expired or the lease was terminated, or the person never had a right to be there in the first place. Maybe they just, broke in one night and decided they were going to live there. All of these situations, really any scenario you could think of, there's 4 things that have to happen for it to be a lawful eviction. So I'm going to start off by talking about those. And so in Missouri, for a landlord to lawfully evict a tenant, the landlord must do these 4 things. First, they have to file a lawsuit to evict the tenant. There's a few different types of lawsuits they could file, but in short, they need to file a lawsuit, and it needs to be one of the eviction lawsuits that we'll discuss here in a bit. Second, they need to serve the tenant with the lawsuit. And there are 2 ways they can do this. They can either have a sheriff's deputy or a special process server actually deliver a copy to the tenant or a member of the tenant's family or household who's over the age of 15. That's one way for them to serve the tenant, and that's called personal service. The other way is called service by posting, and that's when the landlord simply post a copy of the court documentation and the summons on the tenant's door, and then mails a copy to the tenant's last known address, which is usually the address they're still residing in. All right. So in addition to filing the lawsuit and serving the tenant, the landlord needs to actually go to court, and they need to get an eviction order from a judge. And there are a number of ways that they can go about getting that eviction order, and I'm going to talk about those when we go through the eviction process. But in short, they need to go to court, and the judge needs to enter a judgment signed evicting that tenant. And then finally, the landlord needs to request that the sheriff actually execute that eviction. Depending on the type of eviction lawsuit, and also depending on the type of judgment, the amount of time that the landlord has to wait after getting that judgment to execute the eviction varies. But whether it's something they can immediately execute or whether they have to wait 10 days, at the end of that time period, they have to file something called a writ of execution or a writ of restitution with the sheriff's department. And then the sheriff's department is the only one that can come out and actually execute that eviction. And to be clear, what I'm talking about when I say eviction, it's sometimes people get that confused with a lease termination. Lease terminations are different. If a landlord does something, gives a tenant notice, says, I'm terminating your lease agreement, that may be lawful. Landlords can terminate lease agreements without going through this process I've just described. What I'm talking about is the actual eviction, doing something to force the tenant to physically leave the property. And so all lawful evictions, again, whether it's for rent or lease is expired, those can be filed as different types of cases, but the thing that holds true amongst all those cases are these four things. And so if one of these are missing, if, for example, the landlord files the lawsuit, serves the tenant with the lawsuit, goes to court, has a hearing, and the judge rules in that landlord's favor and enters a judgment that the tenant is to be evicted after 10 days, and then that 10 days expires, the landlord goes by and sees the tenant still there. If at that point the tenant does the landlord does something short of, to actually remove the tenant, that isn't filing a request with the sheriff's department and getting the sheriff to come out and do that, then they've committed an unlawful eviction. So all four of these things have to be present. And so that takes me to unlawful self-help evictions. These are commonly referred to as self-help evictions, although the technical name for them under the law are forcible entry cases. A landlord who does a self-help eviction would be guilty of forcible entry under the statute. And what this means is that the landlord's done something that's either forced the tenant out of the home, so evicted the tenant, or they've done something that may not necessarily have forced the tenant out, but effectively did. And they did so without following all of those steps that I just previously discussed that are required for a lawful eviction. So these self-help evictions are always going to be illegal. And again, these are just evictions where the landlord's not followed all four of those steps I've previously discussed. And the most common examples, and I would say the primary examples, are going to be if a landlord goes and changes the locks on a tenant's unit and then refuses to give the tenant. That's a pretty common one. Another common one is if the landlord either contacts a utility company to have the utilities to the tenant's unit shut off, or if the landlord physically goes to the unit and does something to disrupt or turn those services off. That's a pretty common way that a landlord might commit an unlawful eviction. And then finally, another common one is a tenant comes home and the landlord's either removed their property or is in the process of removing their property. Those are all ways that are common ways that landlords might try to evict somebody without going through the lawful procedures. All right, what I've got here is, I just wanted to put up the forcible entry statute so you can see the source of law that I am gathering this from. So when I talk about unlawful evictions, these are actually spelled out in the law, and it says specifically what landlords are not allowed to do. So for example, it states that a landlord or its agents who removes a tenant or a tenant's personal property from the premises without judicial process and court order, or causes the removal or exclusion of the tenant by removing the locks or locks to the premises shall be guilty of a forcible entry and detainer, which is what we discussed. So that covers removing a tenant's personal property as well as changing the locks. And then that second paragraph gets into utility services. So any landlord that willfully diminishes services to a tenant by either interrupting or causing the interruption. So it could be that they've gone and physically done something to disrupt those services, or that they've contacted somebody like the utility company to interrupt those. That person's guilty, or that landlord would be guilty of a forcible entry and detainer as well. And in terms of what that looks like, the statute says that it's the interruption of essential services, and it's including but not limited to electric, gas, water, or sewer services. So those are the examples that they provide, but it's not limited to those. So certainly a landlord that shuts off or has the electric shut off, gas, water, any of that, likely guilty of a forcible entry and detainer. Something else, it's always a possibility. If it, the closer it lines up to one of those things, I think the more likely it is a judge would conclude that that was an essential service. But you know, there are a lot of that would depend on the judge, I think. You know, someone had asked, and I've been asked before about air conditioning. Sometimes landlords will, I've even heard a story where a landlord's gone and actually physically cut the wires to the air conditioning. Well, you know, I don't know what a court would ultimately do with that. I think that there's a possibility that a judge who's, you know, certainly spent any time in mid-Missouri during the summer months and without an air conditioner might be a little more sympathetic. But what I will say is that landlords are allowed to rent rental units without air conditioning. I mean, it could be an issue if the person had air conditioning and then all of a sudden doesn't. That would be more of a contract breach. But you know, the question of whether or not, you know, landlord comes and cuts the cord of the air conditioning, for example, if that could qualify as a forcible entry, I don't know. In my opinion, probably not, but it could. And really any other scenario you could think of that a landlord could possibly do to a tenant to try to force them out by doing something to diminish, you know, their services, you know, internet, you know, a number of things. It's possible to be an unlawful eviction as well.
So passive, like just negligence on the part of a landlord. For instance, you know, I have a client that the air conditioning went out, the landlord refused to do anything about it, went out in June. No evidence that the landlord tampered with it or anything. They're just not, they want the client out, and they're not willing to do any additional maintenance or repair on the property. That would just be a contract issue, not a forcible entry issue.
Yeah, in my opinion, that'd be correct.
Okay.
Yeah, it's only going to be a forcible entry issue if the landlord's done something to make that happen. If it just happened because the unit went out, then that is more of a breach of contract issue. It could be a breach of what's called the implied warranty of habitability, which is just it's a law that requires landlords to maintain property in a livable condition. Air conditioning, whether or not that breaches the implied warranty of habitability, again, that's kind of at best, I think, a gray area, but it could. Certainly a furnace going out in the winter, that would be, you know, breach of the implied warranty of habitability. And there are serious consequences to the landlord for not, you know, fixing those things. But it wouldn't amount to forcible entry and detainer, as we've discussed. It wouldn't rise to the level of an unlawful eviction. Unfortunately, in that situation, the tenant would, most of the time, the tenant would have to kind of make a choice about whether or not they're going to terminate the lease agreement as a result of that breach, or whether they're going to continue forward with that lease agreement despite the breach. And then once they've made that decision, there may be some, you know, additional, you know, the landlord, there may be other consequences as a result of kind of which decision they choose. Again, for example, if they decide that they're going to move out, you know, they may be able to sue the landlord to recover some of the rent they paid during that time period. But, you know, unfortunately, in terms of getting the landlord to actually make those repairs, that's difficult in that situation. Whereas with a forcible entry case, if there are ways to make the landlord correct that situation rather quickly. And I'll discuss that here in a minute. But yeah, there's a process that attorneys and arguably maybe a pro se litigant, somebody who's unrepresented, could do to, for example, get a pretty quick order from a judge for the landlord to remove the locks or to restore the utilities. But when it comes to repair issues, it's kind of a different story. Those take quite a bit longer. And yeah, unfortunately, there are certainly things tenants can do to correct those situations, or at least to put pressure on the landlord to maybe make those repairs. But it's gonna be a little bit different than the forcible entry stuff.
Okay.
So what should a tenant do if the landlord uses self-help? If the tenant comes home and they've been locked out, or Their utilities have been shut off and they either know or suspect that the landlord's the one that did that. Well, one thing they could try that I don't actually have listed up here, but they could potentially contact the landlord and say, you know, hey, what's going on? Put these back on. I can't say that that is likely to be that effective if you already got a landlord who's taking the steps of doing that, but that is one option. And if they refuse to, then at that point, I would suggest calling the police. Again, this is not always effective, but certainly in situations where the tenant is, you know, showed up, they're locked out of their home, probably frustrated to say the least, and there's a landlord who's, you know, actively or just, you know, recently locked them out. The potential for that sort of situation to escalate, I mean, it's there. And so police are supposed to come and maintain order. And in my experience, a lot of police officers will come and not only maintain that order, but often advise the landlord that they need to do this through filing an eviction case, and they'll actually tell them they need to change the locks, so they need to turn the utilities back on. That happens sometimes. There are other times where the police will tell the tenant that, look, this is a civil issue, you need to go file a lawsuit, and really won't do anything beyond that. So that's not always effective, but I do recommend doing that. That's the, if law enforcement is willing to come out and do something, that's going to be the most efficient way, the quickest way for the tenant to get back into their rental unit. Now, if the police will not do anything, then really the only thing a tenant can do in that situation is there's a process, there's something that can be filed in the courts, as I've mentioned, to get the tenant back in, but it's not a straightforward process. And unfortunately, it's not like some cases, for example, orders of protections in domestic violence situations. Those, people can go to the courthouse and there's a form that's just, you know, really straightforward and easy to fill out. And if anybody does have problems with it, the court clerks are actually supposed to assist them in filling that out. So it's, the courts do a lot to facilitate that. With these, the courts really don't do anything to facilitate them. So the best advice I can give them is to contact Mid-Missouri Legal Services or another legal services provider in their area. We put a high priority on these cases, so if they qualify financially, then we'll be able to assist them. And again, it's a pretty complicated process, and so they're going to be best served if they do have an attorney. And of course, if for some reason they don't qualify for Mid-Missouri Legal Services, then contacting another attorney, even if it's a private attorney, would be really in their best interest. But in the event that the tenant's, for some reason unable to get an attorney and they want to try to get back into the rental unit, there are several documents that need to be filed. And what I'll say is that, again, most judges give parties that are unrepresented a little bit of leeway when it comes to filings. They don't necessarily have to do that. In fact, the rules generally are that they're held to the same standard as an attorney. That being said, judges do tend to give them a little bit of leeway. So if I were advising somebody who's been unlawfully evicted and for some reason they could not get an attorney, there's really three things they need to file. And this gives them the best chance of getting back into their home. The first one is just a kind of straightforward lawsuit requesting a permanent injunction. That's just an order against the offending party, prohibiting them from doing something now and moving forward. In this case, locking that person out of their home or shutting off their utilities or doing anything else to interfere with their lawful possession of that rental unit. And then forcible entry. That's what we've already discussed. That's the act of actually whatever it is that the landlord's already done is already a forcible entry. Now, in terms of somebody filing this without an attorney, the easiest way is going to be to go and request a small claims petition. They do have those available at the court, and their tenants are able to just in layman's terms write out what it is that happened. And the courts, again, being small claims court, they are pretty good about interpreting that. And if it amounts to a cause of action, then they'll treat it as such. But I would say the first step is filing a small claims case in a small claims court. There's going to be a fee for that most likely, and they can get that back if they win. But filing that initial small claims case, that gets it on the docket in the future. These next two documents relate to getting them back into their house before that court date, because that, the judge might set that forcible entry case, that permanent injunction forcible entry case for trial 3, 4, 5 weeks down the line. Tenants also have to file a motion for a temporary restraining order and an affidavit. And simply put, this is just, again, if I was explaining this to somebody who, is kind of trying to do it on their own as a tenant who doesn't have a whole lot of knowledge about the law or doing this sort of things, I would describe it as basically a letter with the case number on it, with the parties' names on it, and an explanation of what they want the court to do. Again, that they've got a lease agreement, that the landlord has changed the locks or has shut off their electric, and they want the judge to order them to turn that back on immediately. If it has those basic kind of elements to it, I can't guarantee a judge will treat it the way I think they should, which is as a motion for a temporary restraining order, but I think a lot of judges would. And then the tenant also needs to submit with that an affidavit that's notarized, basically saying that what they've put in that motion for a temporary restraining order is the truth. So as you can see, it's really difficult for a tenant on their own to deal with a unlawful eviction situation. They really, it's one of the more difficult things that I think attorneys who do landlord-tenant law deal with. But if for some reason they cannot get an attorney through Mid-Missouri Legal Services or through one of the other legal aid programs, if they're in another service area, or if they're not able to get another attorney, but they're obviously wanting to get back into their home, the best advice I can give them is file a small claims case, and then in addition to that small claims case, put a separate motion together, and it can be in the form of a letter stating that in addition to that lawsuit that you just filed, you also want the judge to enter an order immediately, putting you back into possession of, putting the tenant back into possession of the rental unit, and also ordering the landlord not to do the things they've done or anything else that would interfere with their possession, at least until they go to court and sort out the forcible entry lawsuit. And then the final thing I'd say is if a tenant finds themselves in that situation and they've filed those documents, they're going to want to bring that to the attention of the court clerk. They won't want to just go and drop that off like they would, another lawsuit. They'd want to specifically talk to a court clerk and explain the urgent, immediate, emergency nature of the situation. And that should result in the court clerk bringing that request for a temporary restraining order to the judge for a ruling that day or as soon as possible. So that's, again, it's, I get the question a lot about, what should a tenant do in those situations? Call the police. If that doesn't work, contact an attorney if you're able to. If that doesn't work, it really is a kind of daunting process, I think, for somebody to try to do without an attorney. But those are the things that, in my opinion, would need to be filed to give that tenant a chance for a judge to look at that and possibly grant something like that without them having an attorney. All right, so like I said, I wanted to spend a little bit of time, I've talked about lawful evictions, and again, all 4 of those steps do need to be present for the eviction to be lawful. Depending on the type of case it is, there could be other requirements, and I'll discuss those a little bit. But the most common eviction cases that a tenant's likely to get served with would be either a rent and possession case or an unlawful detainer case. Those are by far the most common. In fact, since I've been doing landlord-tenant law, I would say easily 99% of the cases that have come in or that I've been involved in have been one of those 2 cases. The other type of eviction case that comes up occasionally is called expedited eviction. They are very rare. One of the reasons they're rare is because it's kind of a misnomer. It doesn't always result in the case moving all that much quicker than the other 2 eviction cases. And there's kind of unexpected things that can come up in these cases. But I just wanted to touch on expedited evictions just briefly. These are only going to come up, and the only way a landlord can get an expedited eviction is if one of the other more lengthy methods would result in imminent physical injury to other tenants or the landlord. So that's one thing the courts look at. If there's evidence that not removing this tenant as soon as possible is going to result to imminent physical injury to others. 2, if not removing the tenant immediately or as soon as possible would cause physical damage to the property, and not just physical damage, but the cost to repair that physical damage should exceed 12 months rent. So basically quite a bit of physical damage to the property. And then it also applies to certain drug-related criminal activity. So there are really just a handful of situations where a landlord can file an expedited eviction case. And kind of the main difference, I guess, why a landlord may want to go this route is there is preliminary temporary relief available. So a landlord could file an expedited eviction and then could also request some sort of preliminary relief, some sort of preliminary injunction against the tenant, perhaps prohibiting them from going on certain parts of the property, up to and including maybe trying to get a eviction, an actual, removal of that tenant from the property pending the hearing, just depending on what the evidence is and how serious these concerns are about injury to other people or damage to the property. So that's one reason why they might want to file one. One of the main reasons why they tend to not file them. One, like I said, they don't really move a whole lot quicker in reality than the other ones. They still have to issue a summons. They still have to serve the tenant. The case still gets scheduled for a hearing, and usually it gets scheduled at least a few weeks out. So they don't move really all that much quicker. And then also, at least when it comes to the drug-related criminal activity, lack of knowledge is a defense. So what happens sometimes is a landlord will file a expedited eviction case against the tenant because somebody was arrested for selling drugs, for example. Well, then that tenant, if they can prove that this was somebody else, they didn't have knowledge that this was going on, that's a defense. And so for a landlord who may just want to try to get the tenant out, regardless, they may choose not to file an expedited eviction case because of concerns about them raising that defense, and instead opt for just terminating the lease agreement and then filing an unlawful detainer case. So expedited evictions, they are rare. I wanted to just mention them because they do come up every once in a while. Like all lawful evictions, they do need to have all 4 of those things. So even with an expedited eviction, landlord's going to have to file the lawsuit for expedited eviction, serve the tenant with the lawsuit, go to court, and at court they would have to prove one of these things I've discussed, that the tenant's done something, or there's evidence that if the tenant's not immediately removed, they're going to cause imminent physical harm to others, serious physical damage to the property, or again, it's some sort of drug-related criminal activity. So again, I don't see these filed very often, but I did want to mention them. Oh, and one other thing I will mention is that they don't, and I guess another incentive for landlords filing these is that under the statute, there are no continuances, or at least the judge should not grant continuances. And, oftentimes, judges are, not always, but they usually will give tenants a continuance, maybe even a couple of continuances to give them a little bit more time to either pay the rent off or work on getting new housing. In an expedited eviction case, technically they're not supposed to do that. I've seen judges do it anyway, and unless the judge is ultimately appealed, then, you know, it's really not going to make much of a difference, but certainly can't be counted on. But anyway, I just wanted to briefly discuss expedited eviction. So now I'll move on to the most common ones, the ones that, you know, tenants you're helping are most likely to come across. And the most common one is going to be rent in possession. As the name implies, it's just when a tenant has, at least allegedly, not paid rent, and the landlord is now seeking to evict the tenant. That's the possession part of the case. And then in most situations, also recover unpaid rent. This can be filed if the tenant owes just 1 month's rent. So, you know, if the tenant, I mean, technically speaking, if the rent's due on the 1st and the tenant doesn't pay, landlord could, you know, the following day file for a rent in possession case. I've not seen that happen. Usually it's, you know, there's some sort of a grace period, but technically speaking, it's 1 month's rent. So if, you know, the rent for 1 month becomes due on the 1st and it's not paid on the 2nd, then the tenant owes 1 month's rent. Rent in possession cases are unique from the other ones in that they've got this defense, and it's called pay and stay. And sometimes it's really the only way a tenant, you know, if their goal is to remain in the rental unit, it's sometimes the only way that they're able to do so, because they can take advantage of this provision, whether or not the landlord's in agreement with it. So under the law, if a tenant owes rent, they have the right to pay that rent. And under the statute, in addition to the rent, they also have to pay court costs. But that doesn't include other fees like late fees and so forth, just the rent and court costs. They have the right to pay all of that up to including the date of the hearing. And if they do that, the case isn't dismissed, it's just stayed. It basically is paused. The rent is no longer an issue, and it just ends, and the tenant's not evicted. So that's, you know, for a tenant dealing with a rent in possession, that's always one possibility, is if they're able to get rental assistance or, you know, come up with other means of paying off the rent that's due as well as court costs, they can avoid eviction.
Now, I've had a client, I think a couple of times I've had something come up where the client has an agency that's helping out with back rent or past due rent, and they tell me that the landlord won't accept the payment.
Okay.
Is that lawful for a landlord to refuse payment from a third party?
Not really. I mean, it's so in terms, so what I would do in that situation is I would just tender the payment in court. I would just go to court and right before the hearing, tell the judge that we've got the payment for the rent and we want to tender that. The landlord's refused it up to this point. The short answer is no, the landlord really can't do that. They're supposed to mitigate their damages. So a landlord would essentially at that point be going into court and saying, they owe me this much in rent. But the reality is that they tried to pay it and the landlord didn't take it. They had an obligation to, even if it was, you know, kind of a partial payment. Although I will say that can get kind of sticky. In those situations, the easiest thing for a tenant to do would be to go to court with the money order or however they intend to pay that. And before the hearing, let the judge know they intend to pay the rent in its entirety along with the court costs. And at that point, that again should stay the case. The judge may put it on hold and direct the tenant to go to the clerk's office to actually pay that. But they have an absolute right to do that under Missouri law. So again, if they found that themselves in that situation, I think most judges would, you know, recognize that they're aware of the law and would allow the tenant to do that because, again, in my opinion, that is the law. You know, I'm always concerned that, you know, if a tenant intends to do something like that, that a judge may, I don't know, I just mess that up. Again, that usually doesn't happen, but that's always a concern of mine. So even in that situation, if they can get an attorney, you know, contact my office, if for no other reason than to go to court and make sure that the judge allows them to exercise that right to cite the statute if necessary, then that's probably the best case scenario. But honestly, I don't think most tenants are going to have an issue with that if they show up the day of the hearing and say, Judge, I've attempted to pay the rent, I'm prepared to pay the rent, and that's what I'd like to do in lieu of having a trial.
And what is the statute that they would have to cite?
Well, if you give me the actual number off the top of my head, I don't recall.
Okay.
Yeah.
I think where it maybe gets a little bit more complicated is some of the agencies, this assistance is designed to keep somebody housed. And so if a landlord is refusing to say renew a lease, or the lease only has a couple of months left in it, especially over the summer here, if a lease ends in August or September, then the tenant may look at that and say, well, it doesn't do me any good to pay this past rent if this agency is going to help me get into a new place instead. Obviously, it helps them look better to a new landlord if they don't owe something to a past landlord. But I think that's where maybe some of these situations are coming up where they can pay, but then they're not going to be able to stay, or the landlord's not going to let them stay long enough to really make a difference.
Yeah. Yeah. I think you kind of highlighted the advantage to a tenant in that situation in paying the rent due, is that it would result in, again, it's not actually a dismissal. Assuming that the landlord's already filed a rent and possession case, and the issue being that the tenant could potentially pay that rent, which would result in the tenant not being evicted, but the lease is going to be up anyway, so the tenant maybe wants to keep that money, or maybe needs that money in order to find new housing. If it's the choices are one or the other, then they do, essentially just have to make a choice, and there's consequences for both of those. And if they don't pay the rent and get the case stayed, then it could potentially go down as an eviction on their record. From a practical standpoint, does it make a difference to landlords whether or not the case ended because the tenant paid the rent and was therefore stayed, or whether the landlord ultimately had to get a judgment against them? For some, probably, maybe not for all of them. I think some landlords maybe just see that the case was filed, and that might be enough for them. So, the impact of that, it's just going to kind of vary. But yeah, in that situation, they may find themselves having to make a choice between paying off the rent and court costs, which would result in the case being stayed, possibly even trying to negotiate something with the landlord to get the case outright dismissed. That would be even better. Or saying, you know what, I'm just going to take the eviction and use this money to move somewhere else, because otherwise I wouldn't have the resources to move somewhere else. That's certainly, I've come across clients that find themselves in that situation. And sometimes if there's nothing to be worked out with the attorney, then they just kind of got to make a choice on which one they're going to do.
Great, thanks.
Now, rent and possession cases, I will add that there are some unique defenses available for rent and possession cases in addition to the pay and stay, as I discussed. The most common one has to do with repair issues that we've discussed previously, specifically that implied warranty of habitability. Again, if a tenant finds themselves in that situation where perhaps they've withheld rent due to repairs, best advice I can give them is to contact an attorney, at least to get their situation assessed and to get some advice on it, because those cases, that is a defense to the payment of rent or the non-payment of rent sometimes, but they're difficult cases to win. I more often than not, I have a tenant who's withheld rent, and after I've assessed the case, I don't think that they've got a really strong habitability case, because it's a pretty high burden. It's not necessarily a legal burden, but in my experience, it has to be in pretty bad shape for the for a court to conclude that the landlord's actually breached that implied warranty of habitability. There are some things that are more likely to result in it, such as a provable insect infestation like bed bugs. Lots of mold, if there's a lot of mold, particularly if it's been tested, furnace going out in the winter, those are pretty strong, habitability defenses. But yeah, anything short of something that's putting the house in real bad shape, I strongly encourage tenants to consult with an attorney if they can. And if they can't, at the very least, it's important to understand that the law allows them to withhold rent. It doesn't mean that they can, not pay rent and then use that rent for other things, unless maybe it's to move somewhere else. And the reason is that in the event that the landlord sues them for rent and possession and they say, well, wait a minute, I've withheld my rent or I didn't pay rent because of the repairs, there's a very good possibility when they go to court that the judge is going to require them to deposit whatever rent is due into an account with the court in order to present that habitability defense. So it's critical if you're talking to a client or a tenant who is maybe having some repair issues and has decided that they want to withhold rent. They can potentially do that. I usually advise against it unless I've had an opportunity to look at it and conclude that I think they've covered all their bases and have kind of set themselves up in a good spot in the event that the landlord does decide to sue them. But at the very least, they're going to need to have that rent money available if if the landlord files a lawsuit. And there's actually a number of steps involved in getting to that point, but I think it's safe to say that if the landlord has an attorney, they're at least going to make the request that the rent be deposited into an account with the court. And in my experience, judges tend to grant that. Part of the reason I think is that the law is that they can withhold it. And if they've withheld it, then it at least arguably should be available to deposit. And again, there's without getting too much into the case law that governs all this, that's most likely going to be the case that they're going to have to deposit that. The only exception will be if they've already moved out. That requirement goes away once they've moved out. So in short, when you're dealing with a tenant who's having repair issues, my advice is if they are going to withhold rent, to keep it and only spend it if they're going to use it to move out of that home that they believe is uninhabitable. Because then if the landlord turns around and sues them and says, you owe me for unpaid rent, the tenant will at least be able to argue in court that they didn't pay rent due to these repairs that the landlord didn't make. And again, it takes away that requirement, or at least that possibility that they would be required to deposit the rent into an account with the court. So that's just kind of a practical piece of advice for tenants. I see a lot of tenants get, to a point where the landlord's filed the lawsuit and they have evidence, maybe really good evidence, that the home was uninhabitable for a period of time. And then they get to court and the landlord's attorney makes a motion for them to pay the rent that's due into an account with the court. The judge grants that, as they really often do in this area at least, and the tenant can't pay it. And the result of that is their defense is struck. And then when they go and have their trial, if they try to testify about these defective conditions in their home, the landlord's attorney is going to object due to relevancy, and they're going to lose. The tenant's most likely going to lose that case. So yeah, just something to be aware of. I know that the repair issues come up quite a bit, and that's really how those need to be treated. I would add to that, everything should be in writing. If you've got a tenant who's telling you that they've got repair issues and they're either considering or have withheld rent, or even if they've not considered that as an option, if they're having repair issues with the landlord, there needs to be something on record, an email, a letter, something that will establish later on that the tenant has notified the landlord about these issues and has requested repairs. So that's just kind of some practical advice about that issue, which I know comes up, at least for me, 80% of my cases probably deal with that to some respect.
So if the tenant has notified the landlord in writing and he doesn't do anything, then what is the next step the tenant should take?
Yeah.
File their own lawsuit, or they have to get an attorney to do that, I would assume?
No, I mean, they probably would be, and it'd be advisable to get an attorney. If for some reason they can't get an attorney, I would advise them to file their case in small claims court. But that being said, it kind of depends on what the tenant's wanting to accomplish. And it's, I think, important to understand what a tenant can accomplish with that sort of lawsuit. Unfortunately, there's not this is all dealt with at the end of the day through money. So if you've got a landlord that's just not going to make the repairs regardless, then I don't know that filing a lawsuit is going to really resolve much of anything. At best, the tenant will get a judgment stating that whatever rent they paid to the landlord during the time that the home was uninhabitable needs to be returned. And so they would just get that in the form of a judgment. So the tenant would still have to go through efforts potentially to try to collect that. So it's not really, it can be difficult in those situations. If their goal is to get the repairs done, Office of Neighborhood Services sometimes getting threats from the city that they're going to turn it over to the city prosecutor. That will sometimes get landlords to make repairs. I suppose occasionally a landlord will make the repairs if the tenant does win a lawsuit, but not always. Sometimes they'll just, throw a fit and figure out other ways to try to get them out, like terminate the lease agreement or, something along those lines. So yeah, unfortunately, from a practical standpoint, in terms of actually getting the repairs made, if you've got a landlord that's resistant enough to that, then there may not be a whole lot the tenant can do. And I would add that if the tenant's already withheld rent, like let's just say that, and this comes up a lot too, where there's repairs that need to be made, but the tenant's not paid rent for 3 or 4 months, well, there's really not a whole lot of incentive for the tenant to even file a lawsuit, because if the tenant wins, they're only entitled to get some or all of the rent that they've paid during that period that the home was uninhabitable back. So if they've not paid rent, then they're not going to get anything back,
right?
Now, depending on the lease agreement, you could also maybe file it as a breach of contract case, and that, so if the landlords also breach the contract, then the tenant may be able to get other expenses like out-of-pocket expenses. They may be able to move and get moving expenses, things of that nature. That really just comes down to what's in the lease agreement. But as far as the implied warranty of habitability, unfortunately, sometimes the best thing I can advise tenants to do is terminate the lease agreement. And if there's any kind of, after that, assess the damages. And if the damages are such that it's worth filing the lawsuit, then to file the lawsuit to try to recover some of that.
So you said the tenant should just file or terminate the lease agreement just by giving the landlord notice?
Okay. So if a tenant, the way I would do it is, first off, I would want that tenant to have something showing that they notified the landlord about the issues, asked for repairs, and that some period of time has passed. The landlord didn't fix whatever it was within a reasonable time. And then I would want the tenant to follow up with another letter stating that due to your landlord's breach of the implied warranty of habitability or breach of the contract, I'm terminating my lease agreement effective on whatever date they intend to terminate that lease agreement. And then follow through on that, return the key. My expectation, if I were a tenant and for my tenants, would be that at that point they would still be entitled to get their security deposit back. And again, if there were specific, at that point, I would just kind of assess what the damages would be. If it were in the lease agreement that the landlord had to make repairs within a certain amount of time, then I would consider that a breach of contract in addition to this breach of the implied warranty of habitability. And that's significant because there's different damages available for a breach of contract claim. So for the breach of contract, they could potentially get other types of damages like moving expenses, out-of-pocket expenses, things of that nature. So it would, kind of be an assessment of that. It just really depends on each individual situation. But unless I'm dealing with a landlord who I think is going to make the repairs, then it's almost always, at least part of it is working on moving and notifying the landlord that the tenant's working on moving, and then maybe trying to get things worked out in the meantime. But unfortunately, these situations often don't get worked out, and so the tenant ends up having to move. And then, at that point, it's just kind of sorting through who potentially owes who what, and figuring out whether or not it's in the client's best interest to file a lawsuit to try to recover damages, if any.
So do you have any sample letter that we could even use as a template or something if the client just simply wants to submit that letter, because you have not fixed the repairs I requested within this period of time, I am hereby notifying you I'm terminating my lease? Would we just, I can see maybe that would be helpful, especially if somebody couldn't get an attorney. Would that be a good idea for us to have a sample letter?
Yeah, I think so. And it would be, I can't say I've got one, but I have a lot of letters, and it would be as easy as just removing any identification, identifying.
We would love to have any sample letters that might be helpful.
Email us, so that would be really helpful.
Yeah, that would be really helpful.
What was the other one?
I think that's the main one, I think.
Okay.
Well, maybe just a sample letter about even how the best way to ask them to repair. And if there's any particular language, maybe we don't need one for that, but we end up writing most of the letters for people about just even, why am I not the same person who committed those crimes 20 years ago? Many of our clients aren't able to articulate a letter. So we'd like to have sample letters for them.
Yeah, both of those you just mentioned, with respect to terminating the lease due to repairs, were just a letter requesting those repairs. I have plenty of those. So yeah, I can, when I get back to the office, I'm actually doing this from home, but I'll be at the office later.
Okay.
I'll be able to get those and go through and just delete various.
That would be so helpful. Thank you so much.
Yeah, no, that's an easy one. I can send those over to you guys probably later on today.
Okay.
I want to be conscious of your time, Roger. It is 10 after 1.
Okay.
We have some more time, but if you want to, I know that you've got a little bit more to cover. It's up to you. If you need to go, we can go ahead and end for now. Whatever you'd like to do.
I could. I'm okay on finishing up, and I'll do it real quick because I know that I didn't realize we were that far over. That was rent and possession case. That's the one you're going to come across, generally speaking, when it's unpaid rent. Real briefly, unlawful detainer cases. These are used by landlords when either the lease is expired, the landlord's terminated the lease due to a lease violation, or perhaps the tenant was never supposed to be there in the first place. They maybe moved in with a former tenant, the other tenant moved out, and now they're there, and the landlord never knew about it, or just kind of the situation where someone's just moved into an empty apartment. That's when these unlawful detainer cases are going to come up. Technically, a landlord can terminate a lease agreement due to unpaid rent, but there's generally speaking, there needs to be a lease provision for that. So if the lease says landlord can terminate the lease agreement for unpaid rent by giving the tenant 10 days notice, then they are likely able to do that. And these are a lot more difficult to challenge than the rent and possession cases, and that's primarily because courts have limited these cases to the issue of possession. If a tenant attempts to assert any sort of affirmative defense or counterclaim, those are actually barred in unlawful detainer cases. So there's no defense of breach of the implied warranty of habitability. Again, this is something to be aware of because, you know, a tenant maybe withholds rent because of repairs, and then the landlord turns around and terminates the lease agreement pursuant to that clause that says they can do so by giving them notice due to unpaid rent. If a landlord goes that route and files an unlawful detainer case, then unfortunately the tenant won't be able to defend themselves with the breach of the implied warranty of habitability. And the most they can do in that situation is file a separate lawsuit. And unfortunately, it's not going to impact them being evicted in the unlawful detainer case. So that's kind of just something to be aware of for tenants who might decide.
And so unlawful detainers, so if it says, so would some leases actually say, if you do not pay your rent, I have the authority to basically terminate, you have to be out in within 10 days to say that? Is it important to read, are leases different, I guess what I'm asking? So some would make it more possible to do the unlawful detainer?
Yeah, it's important to, it's so important for tenants to review their lease agreements and actually agree with them, because lease agreements are the law. I mean, that's where, when a judge gets a landlord tenant case, first place they're going to look is the lease agreement. That largely sets out the rights and responsibilities of the parties. And there are limited things that parties are not allowed to contract to. Like I said, the breach of the implied warranty of habitability is an exception.
Mm-hmm.
So, you know, the lease might say landlord doesn't have to make any repairs. Well, that's true then, except for repairs that impact the habitability of the home. The law still puts that requirement on them. But yeah, in this situation, if a tenant signs a lease agreement that says the landlord can terminate it by giving them a certain number of days notice, and that they can terminate it for unpaid rent, then yeah, in that situation, a tenant could get themselves in trouble, because they might say, I'm going to withhold due to the landlord not making these repairs. And then the landlord turns around and sends them a notice to terminate, saying, pay rent in 10 days or I'm going to terminate your lease agreement. If the tenant doesn't pay the rent in that 10 days, then the landlord can file an unlawful detainer case. And again, these are difficult to challenge, largely because they don't allow affirmative defenses and counterclaims. The only issue at that point would be whether or not the landlord lawfully terminated the lease agreement. The court would look at the lease agreement, figure out what it says, look at what the landlord did, and make a determination as to whether or not the landlord followed that lease agreement. So
Do you have, it seems like that would be a kind of a red flag on a lease. Do you have any, like a list of red flags or something a tenant should look for as they're reading the lease, that if the lease says X, Y, or Z, that could be not a great situation to enter into? Or would the main thing be what the one thing is you just described? I mean, do some leases actually say the landlord doesn't have to make repairs? Or
yeah, and leases that are silent on that. So a lease agreement, I mean, generally speaking, the general rule is that unless the lease agreement requires the landlord to make repairs, the landlord does not have to make repairs.
wow.
So that's the general rule. Again, the only exception to that is if the defect that needs to be repaired is something that makes the home unsafe, unsanitary, unlivable, however you want to describe uninhabitable. That's really the only exception. So yeah, it's again, when it comes to lease agreements, the law largely allows adults to contract the way they want to.
Okay.
There are exceptions to that, but they're pretty limited. So yeah.
Do you have a standard lease that maybe I'm even thinking as we're doing tenant education, we could, I don't know if that would be helpful. Is there a standard lease you typically see 90% of the time, or do they just vary widely?
They vary widely. I mean,
Okay.
some landlords just go online and find one, and it may have a bunch of stuff in it that has no relevance to their property, but they just kind of sign that. There are some landlords who hire attorneys to go through and do a really detailed, thorough lease. So they do kind of vary across the board. This provision,
Oh, go
I'll
ahead.
be honest, the provision I've discussed about the unpaid rent, not necessarily a common provision, but I think it's becoming more common. The attorney in town who handles a lot of landlord-tenant cases, I know he advises landlords to put that in their lease agreement.
He does.
Because I mean, whenever a landlord's trying to figure out whether they're going to file a rent and possession case or an unlawful detainer case, it often comes down to whether or not they're willing to let that tenant stay, even if the tenant pays rent. If they're okay with the tenant staying, as long as they pay rent, they're usually going to file a rent and possession case because there's that pay and stay option. And so they understand that there's a possibility that the tenant will be allowed to continue to live there by paying the rent. If a landlord really wants the tenant out, regardless of whether they pay rent, they're going to be looking to file an unlawful detainer case. And if the only violation is unpaid rent, it's a lot more difficult to terminate the lease agreement due to that. The law is, if it's not in the lease agreement, the law is that the landlord has to demand the exact amount of rent due on the exact date that it's due. And that's kind of a strange rule. It comes from old court cases, but that's the rule if the lease doesn't say anything about it. And there's so many different rules, and it's easy to get kind of bogged down on that stuff.
We have like a crime-free addendum that we've suggested to clients maybe that didn't have the best rental history, that they offer to sign that. But then somebody told me recently, well, I think at least with Columbia Housing Authority, that's now standard part of it, most leases. Would you say that's true? Or is this a good idea for us to tell a client to offer that? I mean, it kind of just shows that the client has no intention of committing a crime if they're willing to bring that up. Do you think that's a good idea?
It can be. I mean, in terms of giving landlords incentives to maybe take on tenants that maybe have evictions on their records or who certain landlords might consider more at risk. I mean, that could be an incentive insofar as if that's violated, it gives the landlord a quicker means of terminating the lease agreement.
Right. Okay, well, we'll keep doing it then.
Yeah.
I just wondered if it was.
It's one of those things where, I mean, obviously, if I have a client who is being evicted for some sort of, something that happened in violation of that, I wish they hadn't signed it. But as far as maybe giving some landlords some extra assurance that, look, the person's certainly promised that they're going to do all these things, but in the event that that doesn't pan out, at least there's a little quicker mechanism in place for them to maybe get possession of the property back.
Okay.
Roger, I'm looking at that bottom line. The landlord is entitled to double the normal rent amount. Have you talked about that already?
No, but that is true with unlawful detainer cases. And so what that means is if a landlord terminates a tenant's lease agreement due to a lease violation, and again, we're talking about terminations, just the termination. So let's say, for example, the landlord sends the tenant a 10-day notice saying that they are terminating their lease agreement effective October 1st due to this lease violation. And October 1st comes and, tenant's still residing there, and maybe even another month or two passes. And then the landlord decides to file an unlawful detainer case. For every day that the tenant remained in the home after the landlord terminated the lease agreement, if the court agrees with the landlord and says that the landlord lawfully terminated the lease agreement, then every day after October 1st, the tenant remained in the home, they're liable for double damages, which is calculated at twice the fair market rental value, which technically could be different than the rent, but generally it's going to be calculated as the rent. So there are serious financial consequences for a tenant that is in unlawful possession of the property, and that actually ties back into the unlawful evictions. a client might, if a landlord terminates a tenant's lease, I mean, what happens most of the time is the landlord terminates the tenant's lease. The tenant doesn't move out, so the landlord goes and changes the locks. Now, in those situations, I can get the tenant back into their home, usually by filing that motion that I discussed for temporary restraining order. Now, that doesn't mean that that tenant's not going to be guilty of an unlawful detainer case. All the forcible entry, the forcible entry is the actual eviction, the actual forcibly, removing the tenant from the property by locking them out or by, shutting off the utilities so that they can't actually live there. That's the illegal part of that. The termination of the lease agreement, that might be lawful. And what that means is that tenant that I get back into their house due to having been locked out, I got them back into their house. Unfortunately, the landlord's likely to turn around and file that unlawful detainer case, which is what they should have done in the beginning in order to make it a lawful eviction, or at least to start that process. They are likely to follow that. So, oftentimes I can negotiate something in those situations to where it's not as bad as it could be, but theoretically, they could then the landlord could file the unlawful detainer and eventually evict that tenant, and on top of that, get a judgment at least for double the rent for every day they remained after the landlord terminated it. So there are still serious consequences for that tenant who, was locked out, even if they are able to get back into the home.
Well, we have kept you a lot longer. Can I ask you one more question that's not related to evictions?
Yeah.
We are working with a woman whose parents passed away. Actually, her mother, the last one, was in 2011. It appears that there was no probate court, no will, no probate court. She's been paying the property taxes every year, our client, since 2011. And she wants to actually move into the house. She does not have a title to the house. And there's a loan to the city from some rehab work that they did. The city is willing to forgive that loan if she can get the title to the house in her name, but we are not sure how to help her get the title in her name. The city is just basically telling us she needs to get an attorney. Now, she is low income on disability, her husband's on disability, so possibly she would qualify to be your client. Is this a type of case that Mid-Missouri Legal would handle helping her get a title? Now, one more thing before I let you answer. The city also said that if the attorney decides this has to go to probate, then the probate court could require that the house be sold. And that then, if that's the case, then the loan would automatically be deducted from the sale price of the house. So you got any thoughts on?
And the siblings won't.
The siblings
contest.
do not want to contest. The siblings want this particular woman, our client, to have the house.
Yeah, so in terms of, I will say it's outside of the scope of what I do, and really outside of, I don't actually know the answer to that. We do have an attorney that does work with respect to mortgages and creditors' rights and things of that nature, and I feel like this would probably be, if it is something that we handle, probably going to be the closest to the type of work that she does. Her name is Kirsten Dunham. She's the attorney that when we did the city presentation discussed mortgages and so forth. She would be the best person to, I think, talk to about that, and I can pass that on to her or send you.
And I think we just maybe email her and the scenario and see what she says.
Yeah, that's what I would start with, because I mean, there's no point. Again, I don't know if it's the type of case that my office is funded to handle, but if it is, Kirsten would certainly be able to tell you that, and then the clients would probably need to call up and do a actual intake. But that's what I would start with first, is getting in contact with her. I can give you her email. here in a little bit if you don't have that.
We have it. She's
Okay.
also she does expungements too, doesn't she?
Yes, she does.
Yeah, she's been a rock star for us, for me with
Yeah.
somebody.
Yeah.
Yeah, thank you so much. I don't know if we have any other questions.
Well, if you do, feel free to email those to me.
Roger, you are a wealth of information. We can obviously talk to you all day, every day. But thank
Yeah.
you so much. We just
You're welcome.
appreciate you.
You're
Yeah,
welcome.
thanks for the clarification. Thanks for your time. I really appreciate it.
Thank you so much.
You're welcome.
All right.
You guys have a good day.
You
Bye-bye.
too.